All rise.
Thank you. Appreciate it. This is State of New Jersey versus Christopher R. Blevins. Camden County indictment number 25051106 and Cape May County indictment number 2506363. Appearances, please.
Clarissa Rouse on behalf of Mr. Blevins.
Your Honor, good morning. Assistant Prosecutor Matt Spittle on behalf of the state.
We're here for sentencing in both cases. The Cape May case had been consolidated by court order for disposition here in Camden County.
That's correct.
Does the state move for sentencing?
Yes, Judge. At this time, the state would move for sentencing on both of those matters, the Camden County matter as well as the Cape May County matter. Judge, part of the presentation this morning before Your Honor would include Mr. Cornell Alston, who was the longtime partner of Ms. Hughes. They both have 2 children in common. And prior to sentencing, Judge, he would like to not only read a letter from his daughters, but also say a few words on behalf of himself, if that is okay.
Sure.
Thank you, Judge. Mr. Alston is in the court, Judge, sitting here in the front row. So whenever Your Honor is ready to proceed, Mr. Alston is.
Thank you. Mr. Rouse, have you had a chance to review the pre-sentence report?
I did, Your Honor. There are corrections that need to be made to both reports. Specifically, the jail credits should read on both from January 13th, 2025 to March 5th, 2026 for a total of 417 days of jail credit
On both matters?
on both matters. Those are all the corrections that need to be made to the pre-sentence report. Also, as part of the presentation, his parents are appearing remotely due to some personal reasons. So I'm asking to have permission for them to speak as well on Mr. Blevins' behalf. I did submit to the court character letters on his behalf. And whenever Your Honor is ready, I would address any of the mitigating factors I would ask that the court consider.
I'd like to do that right now, if you don't mind,
Yes.
because they're on my mind.
Yes.
So, please go ahead.
So, Your Honor, I'm asking you to consider mitigating factors 3, 4, and 8. First, before we get into those individual factors, I want to discuss a little bit about Mr. Blevins. Mr. Blevins is generally a quiet individual. He's a hard worker. As you saw from the character letters, he's often helping people, reliable. Even his employers, both the prior employers, even the ones where he was working just prior to this incident happening, they stated they would want him to come back because of how dependable he was, how he took initiative when prompted, and he was considered an asset to the company. And considering him as an individual, generally he keeps to himself. Generally he's humble and a quiet individual. And he had a relationship with Ms. Hughes, and it often became violent on her end when she engaged when she was intoxicated. In fact, 10 days prior to her dying, her being unfortunately killed, she was violent again towards Mr. Blevins, specifically throwing things around the house, throwing things at him, breaking things in the house. And Mr. Blevins called the police, as we would expect. Nothing much was done. They just went their separate ways to cool down, and then continued as normal in a relationship. 3 days prior to this incident, again, she was intoxicated and engaged in violence towards him. And Mr. Blevins left and went to the precinct to explain what was happening, that she's violent. Nothing was done about it. And then all became well again. And then he went back to they were living together, continuing with their relationship. However, on this fateful day, the incident in this case, unfortunately, it didn't end that way. Not only was she throwing things, breaking things, specifically harming him, but became physical with him. And unfortunately, he responded back. And in that response, he wasn't intended. He wasn't trying to kill her, but he did choke her, and it resulted in her death. He's extremely remorseful. He has a statement he would like me to read to Your Honor. If you want me to read it now, I will. So when we're looking at the mitigating factors for Your Honor to apply, him being under a strong provocation is one of those factors that should be giving heavy consideration, considering his past actions of trying to seek the help from law enforcement. It was never his intention to engage in harming her, serious harming her, and certainly not killing her. So that should be given great weight. Additionally, mitigating factor 4 should be applied, substantial grounds tending to justify, but not excuse, not provide a defense. We have not raised the self-defense claim here, but that should also be given great weight under these circumstances. And frankly, if he had to do it again, he would have chose to engage in similar conduct that he did before, which is walking away and seeking authorities. And finally, mitigating factor 8, results of circumstances not likely to recur, namely because he never intended to take a life. He never intended to take her life. He loved her. And he has learned considerably from this because while he understands the pain he has caused to other people, he understands that he feels that pain also deeply. He did not want her to be removed from this earth. And not only has he learned based on that, but also just in reflecting on what has come of it, he would never engage in that sort of conduct and would take alternative routes. So based on that, I'm asking you to apply mitigating factor 8 and give it great and substantial consideration. Thank you.
Anything the state want to say about the mitigating factors?
Judge, as with all cases, it's quality as over quantity when it comes to the aggravating mitigating factors. I would just ask Your Honor to consider aggravating factors 1, 3, 6, and 9 in this case when looking at those factors and comparing the two.
I'm concerned about double counting. If I was to find aggravating factor 1, how would you respond to that idea?
Judge, well, understanding what you're saying, I would say that the nature and circumstances of this offense, not only is it a murder, but it's also, you have to also include the steps that were taken by Mr. Blevins after the murder. And what those steps were is he removed the body.
I just have to ask you not to call it a murder.
Aggravated manslaughter, correct, Judge, understood. It was pled to an aggravated manslaughter. After Ms. Hughes was killed, she was then removed from Camden County, placed in a refrigerator that this defendant grabbed from his work, put her in that refrigerator, and then drove that refrigerator in his own personal car to Cape May County, and then dumped that refrigerator in the woods. And ultimately, that refrigerator, that body, wasn't located for approximately 5-6 months later. So ultimately, Judge, looking at the factual, the facts that were presented in the investigation, this certainly was done in a, as aggravating factor 1 says, nature and circumstances of the offense, and the role the actor took in committing that offense. And that offense doesn't stop once Ms. Hughes died. That offense continued when he decided to conceal that body. And then obviously, Judge, I would then say that that does not double count with aggravating factor 3, the risk that the defendant would commit another offense. That does not, Judge, I would say, overcount or count, double count 6, the extent of the defendant's prior criminal record and the seriousness of the offense that's currently charged. I think that would be different from aggravating factor 1. His prior record, he does have some misdemeanors out of state that I think Your Honor can consider in this case. And then finally, Judge 9, the need to deter others. So I would argue, Judge, I understand the question, but I would say the extra steps that were taken go well beyond the actual act of the killing.
Mr. Nelson, do you want to respond to that?
Just, Your Honor, when we're talking, I know the two cases for the purposes of sentencing is merging, but they get their individual mitigating, aggravating factors, and mitigating, aggravating factor 1 would not apply to the manslaughter case because it would be double counting. What the state is using to say that it's cruel, heinous, or depraved is essentially the offense for which he's charged on as to the second case. And so essentially he's causing you to have to double count because it's also that case.
Well, no, the way that he desecrated the remains, disturbed the remains, there can be myriad ways to do that. And that's, I think, the point there.
Yes, I understand that, but I believe that when that would go to aggravating factor on the count that deals with the remains versus the manslaughter.
I disagree because I think that the way that the remains were handled were part of the aggravated manslaughter insofar as it denied the family the ability to know where this body was and to exist with the uncertainty of her existence.
No, I rest on the record.
Okay. At this point, I'd like to hear from anyone who would like to speak on behalf of the victim.
Thank you, Judge. Judge, at this time, Mr. Cornell Alston, who is in a long-term relationship with Ms. Hughes, they do have 2 children in common. He would like to not only read a letter that was prepared by his daughter, but also say a few words on behalf of himself, to Your Honor, too.
Whatever sequence you'd like to do it in.
Thank you, Judge. Mr. Alston, you can just whatever you want.
First of all, thank you, Your Honor. I'm going to read a letter from my 14-year-old daughter, who I haven't read it all, so I'm reading it now. It's hard for me to get through, so please give me patience. Her name is Iridessa. She says, to the court, my name is Iridessa Alston. I am 14 years old, and I'm the secondary victim of a homicide committed by Christopher Blevins on December 21st, 2024. Before this incident, me and my sister Gisette and my mom were working on rebuilding our relationship with one another. Due to Blevins' actions, my chances of that reconnection were cut short. I have experienced trauma at such a young age, and it's hard to power through my day today without my mom by my side. He has robbed me of my mom and taken away opportunities to learn from her. I recently started high school, and I found myself feeling like something was missing in the special moments. Someone who is supposed to give me advice on the mean girls at school, or my first crush. Life shifts when you lose your mom. Everything reminds you of the little joys of life, like her favorite candy, her signature perfume, and even the songs that you listen to together. Every day I live in fear of when the next person will leave me. I constantly check on my dad and my sisters and my friends' location to make sure they're okay. And make sure no one walks alone at night or has to ride because of a fear he implemented in me. Every holiday, every milestone becomes painful reminder of what was taken from him. Him being a part of the society makes the world a little bit colder and a little less certain. Because the one person who always had your back, the one who loved you unconditionally, is no longer there. I shall live the rest of my life jealous and envy of other little girls with their mothers, creating memories while knowing the man who interrupted the fantasy is living will only a small price to pay. Why do I have to pay the bigger price than him? Now having to recall memories I had with my mom rather than making new ones, I hope the court will consider the lasting impact of his crime in my life when determining the appropriate sentence for this offender. I seek justice, and I hope that the sentencing will reflect the severity of the crime and help me begin to heal. My 14-year-old daughter. Sorry, give me a minute, please.
You're fine. Take your time. And then next, Your Honor, he would just like to say a few words on behalf of himself.
These are my words, and I labeled it with other words. A stolen future. There will be no Sweet 16 parties, no graduation ceremonies, no weddings to attend, no college graduation to celebrate, no witnesses of the birth of their first grandchild, no being there for their firstborn, no headaches, the headaches of life consoling when they confront the mother, when a mother is needed. There was an opportunity to repair growth and lessons learned. You are forever taking my children's future away, promising a better tomorrow. The last words they spoke to their mother rings loud like an echo chamber. They will never know what their relationship with their mother would have become. You stole that from them. Although there is no amount of time that will bring her back, you should never be able to walk among the free. Still, you have the opportunity after you pay your debt to society. It seems unfair because this debt will never be off my children. They will carry this the rest of their lives. We have been failed by the justice system. My kids should never have to worry about someday their mother's killer will walk down the same side of the sidewalk one day.
Anyone else or any other?
Nothing on behalf of the victim's family.
Okay. Strauss, I'd like to hear from the defendant's family at this point.
Yes. Ms. Bergamini, would you like to go first?
Yes,
I'm sorry, go ahead.
thank you, Your Honor, for allowing us to be here virtually. We apologize that we couldn't be there in person. The first thing I'd like to say is that the situation between Ryan, Christopher, Laura, Corey, and the girls was quite complicated. And they know that. And they also know that Ryan moved to New Jersey with Laura to help them and to help her be a part of the girls' lives. So there was a lot of complicating factors involved that have not been brought up. The second thing is, I just want to say that Ryan, our son Ryan, when he goes by Ryan Christopher, he is not a bad person. He is a good person. If you read the letters of people that worked with him and knew him, as Ms. Rouse said, he was always trying to help other people, and that he was trying to help Laura and her daughters and that whole situation. He was there he was working, he was paying bills, his bills and their bills. He's not a mean person, he's not a bad person. He got himself into a complicated situation, very complicated, and he made some bad decisions and bad choices. I don't deny that at all, and I'm very, very sorry. To his daughters, I want to say that I'm very sorry for what happened. I will live with that sorrow all my life. But again, he's not a bad person. He's done all he could to help other people along the way as he could, and he just got caught up in a really bad situation and made some bad choices. And I hope that you could consider that in your mercy. Thank you so much.
Mr. Bergamini?
Yes, Your Honor. I just want to coincide with what my wife just said. Brian is a truly good-hearted person, helps people, goes out of his way to help people. This situation over the past 9 years has been a roller coaster of emotions for everybody. His fault is he's caring to the extent that he doesn't make the right decisions. Again, everything I just like to go on with what my wife said. I've been his stepfather for 14 years, and he's been a blessing in my life. He's just a very caring person that made the wrong decision, and we would like for you to consider that moving forward, if you could, sir.
Okay. Ms. Rouse, would you like, let me, before I get to the defendant's statement, just remind you that you have 45 days from today's date to file an appeal of your conviction and sentence. And if you cannot afford counsel, the Public Defender's Office will represent you on your appeal. If you miss the 45-day deadline, you can ask for an additional 30 days to file your appeal. But if you miss the extended deadline, you may lose your right to appeal. Have any questions about your right to appeal? You have 5 years from today's date to file a petition for post-conviction relief. Did you discuss your appeal rights at the time to file a petition for post-conviction relief with your attorney? You just have to say yes or no.
Yes,
Did you sign a notice of appeal rights form?
yes,
Based on what you said, I'm satisfied you have knowingly and intelligently executed the notice of appeal rights form and understand your appeal rights at the time to file a petition for post-conviction relief. Is there anything you'd like to say before I impose sentence?
So, Your Honor, he asked me to say it on his behalf because he's sick and his voice is going. He says, I'm sorry for what happened. I'm sorry for the pain and suffering I've caused. I didn't mean for it to happen. I do not know why it happened. I wish I could do things differently and that I just left. I'm extremely remorseful.
All right. Before I issue the sentence, I want to directly address the family and loved ones of Laura. After hearing your words, I now realize that today's proceeding is at its core about a loss, an irrevocable and devastating loss. You've spoken about who she was and the love she brought into your lives, and you have described the gaping void left by her death. You've also expressed openly and understandably the belief that justice has not been fully served by the recommended sentence. The court respects that view. Even as the law prohibits a sentence that exceeds the agreed upon limit, I acknowledge your pain and the frustration that the years of imprisonment agreed upon seem small compared to the life that was stolen and the manner in which it was taken. It is important for you to know that the fact that a lawful sentence is imposed does not mean the court believes it is sufficient to repair the harm or is equal to the value of the life that was lost. No term of years can do that. Justice in its legal form is necessarily imperfect. It operates within legal constraints and negotiated resolutions. It cannot accurately measure the depth of human suffering. Your sense that this sentence is not enough is not wrong. It is a reflection of the magnitude of your loss. It is my hope that you and your daughters find some solace in each other and in Laura's memory and in the love and strength you continue to share. While the sentence cannot heal you, the court hopes the record made today affirms, which should never be in doubt, that Laura's life mattered, that what was done to her was profoundly wrong, and that the responsibility for that wrong rests exclusively with the defendant. Now, even in these circumstances, the court's role in sentencing is to be dispassionate and even-handed. And toward that end, the court makes the following findings. Defendant pleaded guilty to count 1 of indictment 25-05-1106, first-degree aggravated manslaughter, as well as count 1 of Cape May indictment number 25-06-363, disturbing human remains, a second-degree crime. Defendant's plea results from an agreement with the prosecutor. The court has reviewed the criminal division pre-sentence report and finds the defendant is 46 years old and is the oldest of 3 children. He is single and has no children. He graduated from high school and later obtained an associate's degree in automotive engineering. Prior to this incident, he was employed at a car dealership. Defendant is in good physical health and fair mental health. He has a history of substance abuse. Defendant also has prior contacts with the court system. He has 1 district court conviction out of the Commonwealth of Virginia, which is the equivalent of our disorderly persons offense, for altering the price on merchandise. He also has 3 circuit court convictions in Virginia, which is the equivalent of a crime in New Jersey, for assault, for shooting at an occupied vehicle, and for shooting or stabbing in the commission of a felony. He also has a conviction for driving while impaired out of the state of North Carolina. I've read the letters of character support provided by the defendant, and I've listened to the statements of the defendant's parents. And with this indictable conviction, the court finds the following aggravating factors. Number one, the nature and circumstances of the offense and the role of the actor therein, including whether or not the crime was committed in an especially heinous, cruel, or depraved manner. Death by strangulation is especially cruel. It is a method that is inherently prolonged. It is not momentary. It requires sustained pressure and sustained control. The cruelty of this crime did not end with Laura's death. After killing her, the defendant placed her body into a container and transported her approximately 45 miles away, abandoning her remains in a state forest. That act compounded the original violence. It deprived the victim of dignity and death, and deprives her family of the ability to mourn, to grieve, and to begin healing. It substituted concealment for accountability and isolation for humanity. In the eyes of the law, and in the judgment of this court, the disposal of the body was not incidental. It was an aggravating feature that rendered the offense especially cruel and depraved because it prolonged the harm not only to the victim but to those who loved her. And the court gives this factor significant weight. The court finds aggravating factor 3, the risk defendant will commit another crime. This is based upon defendant's prior contacts with the court system. The court gives this factor moderate weight. The court finds aggravating factor 6, the extent of the defendant's prior criminal record, and the seriousness of the offenses for which he has been convicted. The court gives this factor moderate weight based upon the 3 convictions out of Virginia. The court also finds aggravating factor 9, the need to deter the defendant and others from violating the law. The court finds that defendant's prior contact with the court system demonstrate the need to deter this specific defendant. There's also a need to deter the public from committing these types of heinous crimes. The court gives this factor moderate weight. With regard to mitigating factors, the court considered each one individually on its own. The court does find mitigating factor 3. Defendants acted under a strong provocation. The court gives this factor light weight, however, in light of the fact that the response of the defendant exceeded any legitimate attempt at self-defense. The court does not find mitigating factor 4. There were no substantial grounds tending to excuse or justify the defendant's conduct, though failing to establish a defense. The court does not find that mitigating factor 8 applies, given the fact that the court finds the defendant is likely to commit another crime. It cannot find that defendant's conduct was the result of circumstances unlikely to recur. And the court rejects that mitigating factor as well. In weighing the aggravating and mitigating factors, the court is clearly convinced the aggravating factors outweigh the mitigating factors. The defendant is sentenced as follows. The defendant is committed to the custody of the Commissioner of the New Jersey Department of Corrections for a term of 17 years. He shall serve 85% of his sentence before becoming eligible for parole, and upon release he shall be supervised by the Bureau of Parole as if on parole for an additional 5 years. This sentence is to run concurrent to the Cape May County Indictment 2506363. Defendant shall provide a DNA sample and pay costs, 417 days of jail credit, $100 victim compensation penalty, $75 safe neighborhood assessment, $30 law enforcement fee. Count 2 of Indictment 25051106 is dismissed. As to Cape May Indictment 2506363, defendant is committed to the custody of the Commissioner of the New Jersey Department of Corrections for a term of 10 years with no period of parole and eligibility. This sentence shall run concurrent to the Camden County Indictment number 25051106. The defendant shall provide a DNA sample and pay costs, 417 days of jail credit, $50 victim compensation penalty, $75 safe neighborhood assessment. Count 2 of Indictment 2506363 is dismissed. All fines and penalties are transferred to the Department of Corrections for collection as part of any parole which might be granted. For the benefit of the public, including those present, I now wish to estimate the actual time this defendant will spend incarcerated as a result of this sentence before eligibility for parole. The aggregate sentence is 17 years. Defendant must serve 14 years and 6 months before he will be eligible for parole. This estimate cannot be relied upon for appeal or for parole application. The court is going to take a brief recess.
Thank you, Judge.